Good afternoon. The court's going to take up the next case on the court's docket. This is cause number CV 2106199. This is in the interest of Kyla Joel Nestle, a child. The case is set for an adversary hearing today on an original petition for protection of a child filed by the Texas Department of Family and Protective Services. The hearing is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the hearing today on behalf of the department is Investigator Eduardo Galvez, Supervisors Amy James and Angela Medor, and Brown County Attorney Shane Britton. The mother of the child is Jody Woody, and I don't believe she's participating in the hearing today. I'll verify that in a minute. The court will take judicial notice of the court's file to the extent it reflects that on January, let's stand by for just a second. On July 7, 2021, Ms. Woody was personally served with citation and notice of the suit and with the petition and the Zoom video conference link for today's hearing. She is not present at this point. She has not filed any request with the court for a court-appointed attorney, and no attorney purporting to represent her is in an appearance in the case on her behalf. The alleged father of the child, according to the department's pleadings, is Lance Nestle, and if I didn't note earlier, he is present in the hearing. Daniel Willingham is the attorney and guardian ad litem, and Michelle Wells again is the counsel guardian ad litem. All right, Mr. Britton, can you advise the court and the parties what orders the department is seeking today?
Yes, Judge. The department is seeking to be named as the temporary managed conservator of the child, with the parents named as temporary possessory conservators. Family service plans will be created, sets forth those tasks that they're expected to follow throughout this case. I don't know where mom is today. I don't know if anybody knows where she is. And then I would need to ask Mr. Galvez some questions about placement, or Ms. James.
Mr. Galvez, can you advise the court and the parties where the department will propose the child be placed for the time being?
Yes, Judge. The child is currently placed with the maternal great-grandmother, Janice LeBon, here in Early, Texas.
I'm sorry, you said the paternal great-grandmother?
The maternal great-grandmother.
Okay, and what was her name?
Janice. Last name LeBon, Laubhan.
Okay, thank you. All right. And I'm assuming as part of the court's or request of the court, Mr. Britton, the department is also requesting for paternity testing to be ordered to confirm whether or not Mr. Nestle is in fact the father of the child.
That's correct, Your Honor.
Thank you. All right, Mr. Nestle, the purpose of today's hearing is to determine whether or not the court should grant the temporary orders being requested by the department. The orders include an order that would appoint or continue the appointment of the department's Child Protective Services as the temporary managing conservator of the child, meaning the department would have the duty and responsibility to make sure the child's in a safe environment for whatever the duration in this case might be while that appointment continues. It would provide for the mother to be appointed as a temporary possessory conservator with some visitation rights with the child. It would order paternity testing as to you to determine if you are in fact the father of the child. If you were determined to be the father, you would remain involved in the case and subject to further orders of the court. If on the other end you were ruled out as the father of the child, you would be non-suited and dismissed from the case and no longer involved in the case. The orders would also include orders for the department to provide services to the parents in the case to try to address any concerns they might have if the child were placed back with the parent in their care, and it would order the parents to participate in those services. If the court enters those orders, then the court is required to set some additional hearings in the case to check on the status of the case, see how the child's doing, how the parents are doing, and see if we're at the point where the temporary orders that may have been entered can be changed. For purposes of determining how to proceed with today's hearing, I need to know what your position is as to the orders being requested by the department. Are you in agreement with those orders being entered, or are you opposed to those orders being entered?
Sir, I'm all in for whatever I need to do for my daughter. The test, whatever you need to do, I'm willing to take whatever classes, whatever. I know without tests, she's mine, so I'm willing to abide and go by whatever rules I need to go by to do these parenting classes, to do whatever classes I may need to do, take whatever tests I may need to take, sir. So, yes, sir, I'm in to proceed and go forth with this.
Okay, thank you. Let's see. Let me check with the other parties here. Mr. Willingham, what is your position on the orders request?
I'm in favor of the orders, Your Honor.
Okay. And Ms. Wells, as the CASA guardian ad litem?
We're in favor. The only thing that I would like to say, though, is that when this case came in, Mr. Shepard contacted me and asked about this case and a couple of other cases. And so this was a case that that I had said or requested that we not be appointed to. We took the other two. And so I wasn't really expecting that we would be assigned to this case. I'm not sure what happened, but our request would be that we be dismissed from this case as guardian ad litem and that Mr. Willingham be in a dual role, if that's possible.
All right. Mr. Willingham, you have any objection to me appointing as guardian ad litem as well?
No objection.
The court will enter an order substituting Mr. Willingham as the guardian ad litem, as well as serving as the attorney ad litem for the child going forward, and discharge CASA from this case. Thank you, Ms. Wells.
Yes, thank you. And I apologize for having to do that.
No, that's all right. I understand. Mr. Galvez, could you raise your right hand, please? You solemnly swear or affirm any testimony you give today before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And you are, will you state your name for the record, please?
Yes, sir. Eduardo Galavis.
Okay, and would you state your position with the department?
Yes, sir. I'm an investigator with the Child Protective Services in Brownwood, Texas.
Okay, and in that capacity, you prepared an affidavit in support of removal that was attached to the petition that was filed in this case relating to Kyla Jill Nestle. Is that right?
Yes, sir.
And that was based on your investigation of the case?
Yes, sir.
Okay, and as it relates to the mother and the case, Jody Woody, all the information contained therein is, to your knowledge, true and correct?
Yes, sir.
Mr. Britton, any additional questions from Mr. Galvez?
No, Judge, just we would ask to check judicial notice of that petition and that affidavit attached.
Mr. Willingham, any questions for Mr. Galvez?
No questions, Your Honor.
The court, after hearing the evidence and after taking judicial notice of the affidavit that was filed and hearing the announcements of Mr. Nestle in the case, will enter the orders requested by the department. The department remains as temporary managing conservator. I'll order paternity testing on Mr. Nestle. The mother is appointed a temporary possessor and conservator with visitation rights pursuant to the visitation plan to be filed by the department. The court will order the department to provide services to the parents and for the parents to participate in those services. The next hearing in the case right now is set for September 2nd, 2021 at 9 a.m. That's a status hearing. An initial permanency hearing is set for December 9th, 2021 at 11. A permanency hearing and pretrial is set for April 7th, 2022 at 10. A trial is set for May 26, 2022 at 3. And the dismissal date for this case is June 27, 2022. Mr. Nestle, I'm required to notify any parent or potential parent in this type of case that because of the nature of these proceedings, your parental custodial rights and duties to your child may be subject to a restriction or even termination, and your progress on any court orders or plan of service will be reviewed at future hearings. That said, the law in Texas provides that if a child is placed in the department's custody, the department's obligation is to try to work with the parents to get the child back with a parent. or with a relative. So they'll be in contact with you about the case. Attorney testing will be ordered. If you happen to get released before that's set up, you need to make sure you stay in contact with the department so they can notify you how to go in and get tested on that. If you're confirmed to be the father, as I indicated before, you remain in the case and participate further. I've set a number of hearings. It'll be important for you to participate in those hearings as long as
Yes,
you're
sir.
part of the case. If you're released, sure want to get there with the department to make sure you know about the hearings and how to be involved and get any services, including the service, the paternity test set up. Okay. Under the law, in any litigation, as this case progresses, you have the right to retain a lawyer if you feel the need for legal advice. If, as this case progresses, you become opposed to what the department is wanting to do in the case and cannot afford a lawyer, you can make a request for a court-appointed lawyer by filing an affidavit of indigence form with the Brown County District Clerk. If the court determines at that point that you do not have sufficient assets or income to hire a lawyer at that time, then the court will appoint one for you.
Can I do that from? Can I do that from where I'm in Brown County right now as well, or do I need to wait for the paternity test and all that to go through first?
Technically, I'm not authorized to appoint an attorney for a non-parent, which is technically your status right now. You may be the parent, but you've not been legally established. So I'm not authorized to appoint one for you. But if the paternity test confirms you're the father and you want an attorney at that point and cannot afford one, you can make a request by filing that affidavit. Okay.
And could you run the date by which the test would be ran again to confirm that I am the father?
I don't know when the test will occur. I'm signing an order today to order that test. The testing is normally done through the Texas Attorney General's office. It may be once they get the paperwork that they'll either come to the jail and test you if you're still incarcerated. If you're released, you may either get an appointment or you may be able to walk in on a specific day and test at the office. Okay?
Yes, sir.
All right.
Thank
Thank you. All right. That will be adjourned.